Hey everybody, John Skiba here from the Arizona Consumer Law Group. And in today's video, I wanted to talk about settling your claim with a junk debt buyer after a lawsuit has been initiated. Now, what brought this topic to mind is recently I was talking with a client and they were asking me, now that the lawsuit's been filed against them and they're defending themselves, are there opportunities to still settle the debt once the lawsuit's filed? The answer to that is absolutely there are opportunities to settle. There are actually numerous opportunities, but you can get the best deal if you choose the right times when to settle the case. So what I wanted to do is go through some different stages of the case. And this is going to be Arizona specific because I practice law in Arizona. But if you're not in Arizona and you're listening to this, there's likely similar milestones in your state as far as how a case proceeds from the day a lawsuit is filed until you actually end up in a trial. Now, the first opportunity to settle the case is really just right after it's filed. At that point, the law firm that's representing the junk debt buyer, like Midland Funding, Portfolio Recovery, Cavalry SPV, those types of companies, as soon as they file the lawsuit and serve you, they don't have a whole lot invested into it. Frankly, from my experience, the complaint and the summons that they prepared are just boilerplate. They're really just changing out the names and the dollar amounts that they're claiming are owed. The attorney probably just glanced over it, if they even glanced over it, and then they sent it out for service. So at that point, they don't have a whole lot invested into it, and they may be willing to take a lower settlement just to avoid, future and lengthy and costly litigation. So that's one opportunity, is just right after you get served, reach out to them with a particular settlement offer at that point. In Arizona, the next step where I tell people we ought to look at settlement is about 40 days later. Under the Arizona Rules of Civil Procedure, 40 days after the answer is filed, the parties have to exchange something called initial disclosure statements. These documents are essentially both sides showing their cards. They're going to show any evidence they have, documents, lists of witnesses, that kind of thing. That's really your first opportunity to fully evaluate how good or bad their case is. Because in Arizona, they don't have to attach any documents to the complaint when they sue you. They just have to allege what the facts are and what the statutes and the law that they're proceeding under is. So once you get the initial disclosure statement about 40 days later, then you have an opportunity to reach out with a settlement offer as well, because then you can evaluate their evidence and you can point out some of the deficiencies they have or holes or gaps in their evidence as a way to get some leverage to get a lower settlement. Now, if your case is in the justice court system in Arizona, and that deals with cases where the amount in dispute is under $10,000, the court will pretty quickly set what's called a pretrial conference. This is really when the court really becomes aware of your case for the first time. The judge is aware that there's actually a pending dispute. And at that pretrial conference, they always ask the parties to sit down and discuss if there's a possibility for settlement. So I tell people to be prepared when they go to that hearing, and when I go as an attorney on their behalf, I go prepared with a settlement offer or at least some type of proposal to try to resolve the case. So that's an excellent place as well. Another one is prior to, you have an opportunity to settle prior to any large event occurring in the case. For instance, in Arizona, when you are dealing in the Superior Court, which is dealing with cases over $10,000, the parties are going to have to proceed through what's called compulsory arbitration. This is kind of like an informal trial proceeding where they appoint an attorney to act as the arbitrator and really determine who wins or loses. This generally takes quite a bit of time for the attorneys to prepare for. There's the cost of going and actually attending the hearing and presenting it, and there's the possibility that either side could lose in that arbitration. Because of a major event like that, I say a good time is to submit an offer is right prior to that, to help that party avoid having to put all the effort into getting prepared. They may be willing to take a settlement rather than having to go through the whole steps and preparations of getting ready to go to arbitration. Another time is after arbitration, particularly if you've won, or if you've won some other type of procedural motion. Let's say that they wanted their witness to appear telephonically at trial, you objected to that, and now the witness is going to have to appear in person. Any kind of little victory along the way like that, following that up with a settlement offer is a good way to try to get this resolved, because of your little victory, you are in a better position to make the case more difficult for them to prove. So one thing that people are concerned about that I talk to that are dealing with these kind of lawsuits is they specifically are worried about whether they're going to be able to use the settlement offer against them in the trial. essentially you're in this case and you offer to pay them X amount of dollars, and then they immediately go to the court and say, look, judge, they're admitting they owe the debt. They've already offered to pay us so much. Well, the rules of evidence prohibit the other party from actually using that information. Now, the rule is Rule 408 on the Arizona Rules of Evidence. It's also Rule 408 in the Federal Rules of Evidence. And probably there's something similar in your state if you're not in the state of Arizona. Let me read through it with you really quickly, just so you have an idea of specifically of what it's saying. It says under Rule 408, it says prohibited uses. Evidence of the following is not admissible on behalf of any party, either to prove or disprove the validity of an amount of a disputed claim or to impeach by a prior inconsistent statement or a contradiction. Then it goes down to subsection 1, furnishing, promising, or offering or accepting, promising to accept or offering to accept a valuable consideration and compromising or attempting to compromise the claim, and subsection 2, conduct or a statement made during compromise negotiations about the claim. What that says in English is it basically says this, that if you make a settlement offer, they cannot then take that and use that against you. It's not admissible in court, and you could object to them even discussing any types of settlement offers that have been made. So you can make those offers without the worry that it's going to come back to bite you in the end. And this rule is in place because the court wants to encourage the parties to discuss possible resolutions of the case without having to worry about it causing them harm going forward. So those are some different opportunities you're going to have after a lawsuit is filed to get the case settled. Generally better to get that done prior to the entry of judgment, because once judgment is entered, a lot of the power shifts over to the junk debt buyer and you're not going to get as good of a deal. If you want to learn more about how to handle these cases or more about what we can do to help you to assist in handling these cases, head on over to my website at consumerwarrior.com. That's consumerwarrior.com. If you're not in the state of Arizona, again, I'm only licensed there, so I can't practice in your state. We do have some online video tutorials and templates and forms that could help you out. Those can be found at legal.coach. Thanks for watching today.